Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Ms. Williamson. Appreciate everyone's patience bearing with us as we do this Zoom proceeding. It's still somewhat new to us, but you as practitioners may do this all the time. So if you'll bear with us, our biggest struggle is one of us starts to talk and we forget to unmute ourselves. So we all try to catch each other on that. We appreciate your patience in getting this case rescheduled. This pandemic has had an effect on everything, but particularly with us holding court. So thankfully, because of these technologies, we're able to proceed with this proceeding today. So at this time, the court will call cause number 11-19-248 CV, Hunsaker versus Richardson. Ms. Knapp, are you ready to proceed?
I'm ready, Your Honor.
You may.
Okay, may it please the court and Mr. Turner. This is a somewhat unusual case because this is a summary judgment. At the summary judgment hearing, it really seems like everyone agreed there was a fact issue. And rather than denying the motion for summary judgment, the trial court just basically ordered new evidence. And once that was filed, weighed it, made credibility determinations regarding it, and then issued the judgment. The bottom line is I don't think is a summary judgment case. There are many issues that ought to be tried to a jury, and my clients feel like they have a right to have their case heard by a jury. This was a traditional summary judgment on the plaintiff's conversion claim. There were a number of other claims that were dismissed through various non-suits, but that's the one that the judgment was issued on. So to affirm it, there needs to be conclusive evidence to establish the conversion and no fact issue on any of the affirmative defenses. So I'll first talk about the conversion issue. A conversion under Texas law requires a wrongful dominion and control over someone else's property. And there's some dispute, I think, in the briefs as to whether Texas law does require a wrongful dominion or control. I think even the cases cited in the Ms. Richardson's brief do recognize that there needs to be some unlawful and unauthorized control. They refer to malfeasance in the acquisition of the dog. And I think Ms. Richardson, I don't think anyone's denying that my clients did nothing wrong in adopting this little rescue dog that they did. But turning to the issue of whether this is the same animal or not, and this is one thing that there's just a genuine issue of fact on, and we've laid out in our briefs in a table. I tried to make it kind of clearer to read by putting in the table, but there are a number of differences between the two animals that are described. When I was reading the record again and getting ready for this argument, the thing that really strikes me is the scarring that my clients observed on this dog when they arrived at the rescue place to pick her up. They described scarring from her mouth to her toe. I mean, her whole length of her body had scarring on it. And to them, they thought it was so noticeable that it was a distinctive characteristic of the dog, and thought that someone ought to be able to recognize the dog just solely by the scarring. That's not the same description that we get from Miss Richardson and her family, who describe a perfectly well-kept little dog with maybe a little scar on her foot and maybe a spot on her ear that wasn't a scar, but she had some hair loss on an ear where a rattlesnake bit her. That just sounds like two different animals. And I think a jury is entitled to look at that evidence and decide whether it is or not. And there are numerous other issues on whether this is the same animal or not. You know, there's evidence in the record that the dog that my clients adopted was 6-7 years old. The dog that Miss Richardson describes was much older, in dog years, 11 years old. And that's a significant difference as well. There are also differences in the just health condition of the dog. The dog my clients adopted needed a teeth cleaning, was very skinny, malnourished, underweight, iron deficiency. The dog that Miss Richardson describes has, really paints the picture of a perfectly healthy little dog with super well-brushed teeth, not a very skinny dog, receives all this veterinary care and is under constant supervision. So there's just a number of differences in how these dogs are described, and enough that a reasonable juror could look at that evidence and say, look, these are not the same animals. And another thing that there is evidence in the record that the dog that my clients adopted, where it was found, there's some dispute about whether it's found in Stephenville or in Lipan or in, and I apologize, I'm from Amarillo, so I might be completely saying that word wrong, but, or in Palo Pinto County. There's an issue on that we can address later, but there was a dog that was seen running loose several times, maybe upwards of 4 times, that Garrett Matthews and other people in that neighborhood described running around. And the dog that Miss Richardson had, she said that dog had never gotten out, maybe one time had gotten out in that same period of time. And so that's another issue of, maybe there were 2 little dogs running around in this neighborhood. And I think it's perfectly reasonable to assume that, for a jury to get to decide whether that is the case or not. And so that's really the first fact issue that we think a jury ought to be able to decide, is whether these animals were the same or not. And of course, if the animals are not the same, there can't be a conversion, because there's then not conclusive evidence that my clients have someone else's property. And so I'll turn into another element on the conversion claim is you can't convert property that you are the lawful owner of. And, my clients adopted this little dog. They pay, and we say adopted, of course, because we're talking about a dog, but we talk about it in terms of goods, as the Texas Supreme Court has recognized that dogs are personal property. They purchased this little dog from the Dusty Puddles Dachshund shelter. They paid $200 for her, and they got the dog. And so, we have made the argument that they are therefore the lawful owners of the dog. Mr. Turner's argued that, well, the Dusty Puddles rescue shelter didn't have basically didn't have the title to the dog in the first place. And this gets back to the issue of where the dog was found and, how does that play into the ownership? And again, that's a fact issue as to where the dog's found. There's evidence in the record the dog's found in Stephenville. There's evidence that the dog was found in Lipan. There's evidence that favors the movement, I suppose, that the dog was found in Palo Pinto County, in which case that evidence ought to be disregarded at this summary judgment stage. But under the Hood County animal control orders and under the ones that apply in Stephenville, if you hold the dog for a certain period of time, then you're deemed the owner. The Hood County animal control order says that after 5 days, the person who keeps, harbors, feeds, shelters, or allows a stray animal to remain on his property, and it says, quote, shall hereby be deemed the owner of the animal. And so under that animal control order, the Dusty Puddles Rescue Shelter would have been the owner of the dog. There's no dispute that, they held the dog for 10 days. And that's certainly more than 5 days. And so we think they were the lawful owner, and therefore my clients, when they purchased the dog from the lawful owner and now are the lawful owners themselves. Tying in somewhat to this argument is a good faith purchaser argument. And we've laid out the elements in the briefs. I'm sure the court is aware of what a good faith purchaser is, but someone who purchases from a seller in good faith with valuable consideration. Under the common law, there's an extra requirement that they have no knowledge of someone else's claim. There really is no dispute over those elements under the common law or under the UCC, as I understand it. Ms. Richardson doesn't dispute that my clients purchased this dog from the animal shelter and that they did that in good faith. She said in her deposition she didn't think they did anything wrong in their actions. Instead, they argue that, well, again, the shelter didn't have the title, so they couldn't pass it on, and you can't acquire the title that the person you purchased from didn't have. But the Texas Business and Commerce Code, and that's in the Good Faith Purchaser Statute 2.403, says even a person with a voidable title can pass good title to the good faith purchaser for value. And so we would argue that even Dusty Puddles at least had a voidable title in the dog. And so what's a voidable title? Well, I can tell you what a void title is, because I have seen some cases discussing void title when someone intentionally steals something from someone. Cases talk about voidable title. Even if you defraud someone in getting a piece of property from them, that is a voidable title. And so under the UCC, that voidable title can be passed as good title to someone who is a good faith purchaser. And so, you know, Dusty Puddles didn't do anything wrong here either. I don't think anyone's saying that they did anything wrong. They did what animal shelters do. They took in a little, you know, by the accounts in the record, a malnourished, skinny, you know, dog that had been wandering around, and held it, gave it vaccinations, took it to a vet, did all these things to take care of it, and then sold it to a couple who they deemed to be good dog owners. And so, you know, if someone who defrauds someone into getting an animal has voidable title, then certainly someone that did nothing wrong has at least a minimum of voidable title and should be able to pass the good title on to a good faith purchaser for value. And so we do believe that our clients are either had the lawful title to start with at a minimum, or the good faith purchasers of the title, and the summary judgment ought to be reversed on that as well. We raised a number of affirmative defenses. The good faith purchasers, kind of a defense and an affirmative defense. And then we also have raised the defense of abandonment and estoppel, which are fairly closely tied together. You know, on the abandonment issue, I think there's a fact issue on both of them. The common law contemplates a negligence or carelessness standard on an estoppel. On an abandonment, there's maybe more of a mens rea argument, but under either, I think there's a fact issue. And it seems like the main argument on the other side has been that, well, we don't know what Ms. Richardson was thinking, if she intended to abandon the dog, so we can never prove an abandonment. And I don't think, especially at a summary judgment stage, you know, we don't have to prove what she was thinking. Maybe someone could never prove what someone else was thinking, but that's why the law allows circumstantial evidence. And if you look at the evidence here, we have a little dog, and again, assuming this is the same dog for the sake of argument, a little dog wandering around the countryside. Several of the neighbors thought this dog had been abandoned. The woman who picked the dog up thought she had been abandoned. She describes a kind of a helpless little dog wandering around in the country, very scarred, not microchipped, not collared, not ID'd. And then after the dog's lost, people looked for the owner. There was no website posting, no signs, no nothing. And reading the evidence in the favor of the non-movement, which is my clients, there certainly is a fact issue on the issue of abandonment and the kind of closely tied together issue of estoppel. And so with those fact issues as well, on top of all the other reasons, we think that the summary judgment was improper and this case ought to be sent back down for a trial. And I did a whole lot of talking. I probably talked too fast because court reporters are always telling me that I talk too fast. So if you have any questions, I'm happy to answer them, or else I will cede my remaining time.
Ms. Knapp, what's your position on the Supreme Court case, the 2016 case that the appellee relies upon?
On the Lyra case. So
Yes.
The Lyra case was first an appeal from a bench trial. So very different procedural posture than we have here. And that case is talking about the Houston ordinances and interprets the word impounding, which is it's a different scheme, different ordinance than the ones that we have here in this case. The Lyra case also, interestingly though, if this would have happened in Houston, the same fact pattern that we're under, and that, under those facts, I think my clients would be entitled to the dog because they had a 30-day time period to claim the dog. And we don't have anything about that in our statute, but I do think that's interesting. Also, the Lyra case does contemplate the ability of these animal control orders to change the ownership of the animal. And so I don't think Lyra is really directly on point because it's really talking about ordinances that just aren't applicable here, and it's from a bench trial and not at the summary judgment phase.
Any other questions?
I have a question. Ms. Knapp, you've raised the issue of the Hood County Animal Control Order. Wouldn't that order apply only if the dog were found or confiscated in that county?
I think that is right, but I think there is summary judgment evidence that the dog was found in Hood County. There are multiple declarations in the evidence that talk about the dog being found in Lipan, and that's in Hood County. So, and then there's also summary judgment evidence that the dog was found in Stephenville. Again, like, this is a fact issue that ought to be sent back down to determine, but even under the Stephenville ordinance is similar, and it has a 3-day wait instead of a 5.
Okay.
Any other questions? If not, thank you very much for your argument. Mr. Turner, are you ready to proceed?
Yes, Your Honor. May it please the court, Ms. Knapp. Your Honor, just factually, this dog was given to my client's 8-year-old son by his great-grandmother on his birthday. The family had the dog for 11 years until she wandered across the road, Tuggle Road, and was grabbed by a woman from Lubbock and taken to Lubbock. The dog is now 13 years old, in bad health, recently underwent a splenectomy and has heart problems. And frankly, this case is about running out the clock by prolonging litigation until the dog dies. If the case is remanded, that's what will happen. let me address the last points that Ms. Knapp made before I go to identity. Strickland versus Medlin is not only on point, it's dispositive in this case. In Strickland versus Medlin, the court went out of its way to say that the law abhors a forfeiture of property. And of course, it referenced the Strickland versus Medlin case where the court said that dogs are property. And the court said the law abhors a forfeiture of property and ordinances shall be construed to prevent a forfeiture of property. Here we have a Hood County ordinance that says dogs running at large may be impounded. Well, obviously Hood County Commissioner's Court doesn't have authority to affect the property rights of people who live outside of Hood County and don't go into Hood County. Secondly, the dog was not impounded for running at large, so it doesn't fall under the Hood County ordinance. The dog was picked up by a private citizen and taken to a rescue group 250 miles away. And then as far as the Hood County ordinance saying that after possessing, harboring, or feeding a dog for 5 days, the dog becomes the owner of whoever's feeding and harboring the dog. Well, that clearly doesn't apply. In this case, that ordinance was meant to discourage people from feeding stray animals. It wasn't meant to change the title to property after 5 days. If that was the case, Your Honors, then a thief who steals a dog and manages to hold on to the dog for 5 days suddenly becomes the dog's owner under Ms. Knapp's interpretation of that ordinance. Or if a Hood County resident decides to go on vacation and they put their dog with a kennel, well, after 5 days, the owner would come back from vacation and they no longer own the dog. So I think that ordinance cannot be interpreted to terminate someone's ownership rights after 5 days when you consider that with the Supreme Court's pronouncement that we have to interpret ordinances so as to prevent a forfeiture of property. Let me, at this time, I would like to talk about identity of the dog. As the court saw in the briefing and the record, the trial court called this gamesmanship, this arguing over identity of the dog gamesmanship, waiting until 10 months into the lawsuit before contesting ownership, and then proffering evidence that the court didn't think contradicted or raised a fact issue about ownership. Appellants talk about it wasn't fair for the court to decide ownership before they deposed the dog's owners. Well, they had 10 months to take depositions, but the evidence offered by the Hunsakers actually does not contradict the 13 affidavits filed by people who knew my client's dog, including her veterinarian. Their summary judgment evidence does not contradict any of that. It doesn't raise a fact issue, and I'm going to do this quickly. Age of the dog. They say that, well, there's a record from a rescue group in Austin where somebody wrote down that we observed the dog was between 6 and 8 years old. There's nothing in the record that shows this person, how they arrived at that number, or that they were qualified to determine the age of an animal. And also an estimate by a layperson that an animal is 8, I submit does not contradict the fact that the dog is 11 years old. I mean, what layperson is able to tell the difference between 8 and 11? I submit that does not raise a genuine fact issue.
Well, at the trial court level, did you object to the competency of that witness to express those views?
Your Honor, I'm going to have to confess I don't remember. and then the location of the dog, they said the dog was, the appellant relies on the fact that my client said in her deposition that she saw on Facebook that some unknown person said the dog was taken from Stephenville. Well, that's their evidence that the dog was, somebody saying the dog was taken from Stephenville. It's something my client read on Facebook that was posted by an unknown third person. That's not evidence that the dog was taken from Stephenville. The appellant relies on a record that says the dog was found on a back road in Stephenville, but the record doesn't identify who that person was, or there was no showing that they had any personal knowledge where the dog was found. The description of the location, the appellant says that back road, there's the record from the Lubbock Rescue says it was a quote back road versus one of their witnesses who said that the dog was taken at a child's birthday party. Well, that witness actually said it was taken from a child's birth. The dog came out of a wooded area and went to the house where the birthday party was. Well, the wooded house, according to the evidence, was on Tuggle Road. That does not contradict the evidence that the dog was taken from Tuggle Road. Scarring on the dog, once again, there was no showing that this person, first of all, what they considered to be scarring versus simple hair loss, or there was no showing that their idea of a scar is the same as my client's idea of what a scar is. And then their claim that there were numerous scars, well, there was nothing in the record showing that these numerous scars existed at the time my client had the dog, and she only had one scar. I mean, this was weeks later that this person is saying numerous scars, weeks after the dog left. The living conditions, they rely on, there's someone who said that the entry in the Lubbock rescue record said that the dog probably belonged to an elder, whereas my client, the dog lived with her and her family. Well, I mean, that can't be competent summary judgment evidence when somebody says, I looked at this dog and I could tell that she probably belonged to an elderly person. I mean, that can't be competent, reliable, genuine, or summary judgment evidence that raises a genuine fact issue. The teeth cleaning, they said that they said that there's a veterinary exam that showed the dog needed teeth cleaning, whereas my client said she brushed the dog's teeth regularly, took the dog to the vet. Those two things don't contradict each other. I mean, taking a dog, brushing a dog's teeth and taking the dog to the vet, that does not mean that, I mean, saying that the dog needs a teeth cleaning doesn't show that it's a different dog. I mean, I brush my teeth all the time, but sometimes I need a teeth cleaning. I mean, it doesn't raise a genuine issue of fact. Weight, the rescue records say the dog was skinny and underweight versus my client who said the dog's not skinny. Well, first of all, skinny is very subjective. I mean, that's like saying the dog we got was cute, but this other dog was ugly. I mean, who's to say what skinny is? That's very subjective, and I submit that doesn't raise a genuine fact issue. Also, notably, the veterinary records that were submitted by the appellant, where their veterinarian examined the dog, those records say nothing about the dog being skinny or underweight. This was only an intake person at the rescue that said this. Iron deficiency, they say, well, the dog the Hunsakers have was iron deficient and anemic. And they say, well, that shows that it's not the same as the dog that got necessary treatment. always got necessary veterinary medical treatment. Well, I submit that being anemic does not contradict a dog that gets regular veterinary treatment. I mean, and also there was no showing as to when the last visit to the vet was. I mean, the anemia could have arisen afterwards. I mean, it's just not legitimate summary judgment evidence that raises a fact issue. As far as the good faith purchasers, excuse me, my mouth is a little dry here. The Business and Commerce Code says that the purchaser takes all title that the transferor has, and a merchant can transfer all rights that they have, all rights that the entrustor had. Well, in this case, the entrustor, Melanie Tatum, when she grabbed my client's dog on Toggle Road, where my client lives, and took her to Lubbock, she didn't have title. She didn't have voidable title. She had no title. I mean, I don't know how you could say if I go over to your house and I grab your dog, I have voidable title. I mean, that's not the law. And if she didn't have any kind of title, she couldn't give any kind of title to the rescue group, and thus the rescue group had no title to transfer. Otherwise, what we're saying is, if I'm walking down the street and I see a cell phone and I pick it up, that now if the owner of the cell phone wants to get it from me, well, I've got a voidable title. I mean, that's not the law. There's no title. So I submit that they're not good faith. It doesn't rise to a genuine fact issue. Now, abandonment, there is no evidence of abandonment. I mean, the so-called evidence cited by the appellant for abandonment, it's not evidence of abandonment. They say Melanie Tatum, the woman who found the dog on Toggle Road, that she had a subjective belief that the dog had been abandoned. Well, that's not evidence of abandonment, because somebody thinks the dog was abandoned. Not being microchipped and not having a collar on at the time is not evidence of abandonment. It's evidence that the owner didn't microchip their dog. And it's evidence that the owner didn't put the dog collar on the dog, but it's not evidence that this person intended to relinquish permanently ownership rights to her dog that she'd had for 11 years. Failing to ask one neighbor, the appellant's brief says neighbors, but she didn't ask the neighbors. The fact that my client did not ask one neighbor named Garrett Matthews, have you seen my dog? That's not evidence of abandonment. That's just evidence that, well, here's somebody she didn't ask. It's the same thing with Facebook, saying that my client said in her deposition that she did not look on Facebook, and that somehow constitutes evidence of abandonment. That's really a stretch. I don't even use Facebook. A lot of people don't. Her not looking on Facebook could mean any number of things. It's not evidence of abandonment. Maybe it's evidence that she didn't do a proper, thorough search. And then finally, let me mention estoppel. There is not a case in Texas that says mistreatment of personal property. If a person mistreats their personal property, they are estopped from asserting ownership in that property. There's no Texas case that says that. And as the Texas Supreme Court pointed out in the Strickland case, the court said, in Lyra, the court said that mistreatment by the owner of a dog does not affect ownership rights. I'm paraphrasing. The court said that there's a vehicle. If a dog is being mistreated, the Health and Safety Code has a vehicle to deal with that, but it does not. I mean, sadly, in Texas, you can you can beat your dog all you want, but that doesn't affect ownership rights. You're not stopped from claiming ownership in an animal that you abuse. I'm not saying my client's dog was abused, but the point is you can't lose ownership rights in personal property by estoppel. I know there were some other things I wanted to mention, but if your honors have any questions, I'd be glad to talk to you about those.
Any questions?
I think I have one. If I can formulate the question properly, y'all bear with me while I attempt to. And if I don't do that, well, call me on it, okay? And I'll try to phrase it appropriately. I understand all the latter issues that you've argued, Mr. Turner, in connection with abandonment and those other legal theories or affirmative defenses included in that. But I think they all, or to me, it seems they all relate back to, before that we get into that, we first have to decide the issue about the fact issue about, is it one dog or two? That sort of thing. And we can look at the record, of course, and answer Judge Trotter's question about whether anybody objected to those affidavits or not. But on review, are we required to check credibility and all that sort of thing? Or is the only thing that we need to do is look to see if there is in fact a fact issue? Does that make sense at all? And
Yeah,
feel free to say no.
Yes, it makes sense to me, Your Honor. And no, I don't think it's up to this court to make any determinations as to credibility of the witnesses. And I agree that this court is strictly limited to determining was there sufficient summary judgment evidence to raise a fact question as to the identity of the dog. My point is that none of these things that they said, whether they were objected to or not, as not having personal knowledge, they don't rise to the level of raising an actual genuine fact issue.
I guess I'm sorry to interrupt you, but I guess then when does that occur in your opinion? You've got affidavits and summary judgment evidence going both ways. I own it, no, I own it, kind of thing. And it seems to me your arguments might relate more to, well, they weren't in a position to know that, or they didn't have firsthand knowledge, they didn't have personal knowledge. It's just not very good. And I know that even the trial court, when the question was first brought up, he was a little bit miffed, I think, and said, "Why do you wait so long now to bring up a fact issue in this case?" And then later there were some 13 affidavits, I think, filed later.
Yes,
after after there was an inspection of the dog, and I guess I'm asking, does that 13 affidavits change anything, or would the fact issue already exist if one did, as the trial court said that he thought it did? Or are we just arguing about those things we don't even look at? I mean, I understand we don't judge credibility. That was kind of a rhetorical question. But I fail to see how an issue of ownership doesn't involve some kind of fact issue. And you straighten me out.
no, I understand what you're saying, Your Honor. I think when I brought forward 12 witnesses who knew this dog and a veterinarian, we gave the judge lots and lots of summary judgment evidence that this was Sally, these Hunsakers have my client's dog. But and I think at that point, it was up to the other side to bring up summary judgment evidence that is not the same dog. And I'm saying that their evidence did not say that it was. Saying the dog is skinny that's not enough. That's not summary judgment evidence. I'm over my time.
Thank you, sir. I appreciate your answer to my question. Thank you very much.
All right. Thank you, Mr. Turner. Ms. Knapp, you'll have 5 minutes for rebuttal.
Thank you, Your Honor. And Mr. Turner, I'll just jump on the question of the fact issue, addressing Justice Wright's comment. I think that on a summary judgment, if a fact issue existed in the first place, the fact issue still exists today. The question of whether there's a scintilla of evidence to support my client's position, that would be the standard. And if there was before, there still is. And the fact that they've amassed, family and friends that'll side with them, that's just a question for the jury. If they, march 13 people in front of a jury, that's for a jury to look at, but that's not something that ought to be decided on a summary judgment. And Mr. Turner's gone through, our kind of chart of differences between these two animals, and really asked this court to indulge in inferences that would favor his client, which is the opposite of what the summary judgment standard is, where all inferences ought to be indulged in favor of the non-movement, the Hunsakers. And so I don't think, with all due respect to Mr. Turner, I don't think that it is appropriate for this court to decide that when Miss Richardson used the word scar, she meant something different than the word scar that my client used. That's an inference that the court ought to read in favor of my client to say that, yeah, they were talking about the same thing and the two dogs have different scarring patterns and they're different dogs. And the same thing with the word skinny. And as far as the evidence that, and I don't believe that it was objected to, I would have to double check, but I don't believe that any of the summary judgment evidence that our client submitted was objected to. But, there's a difference in the age of the dogs, difference in where they're found. And that's not just a Facebook post. There's evidence in our client's affidavits or declarations that the dog, they were told the dog was found on a road in Stephenville as well. So it's not just coming from a Facebook post. And on the issue of abandonment, again, I think this is asking the court to indulge in inferences that would favor the movement, which is not appropriate. There's summary judgment evidence that this dog had been running around carefree many times, and several of the neighbors thought this was an abandoned dog. And the fact that, 3 people, at least in the record, there's one neighbor that tried to adopt it out, the Garrett Matthews, and then the woman who picked the dog up ultimately all thought this dog had been abandoned. And the fact that they did, based off their observations of this skinny little dog running around the country with no collar and no tags, is some evidence that a jury could look at those same facts and make that same determination. And I think that it's just a case that's right for a jury trial and not something that ought to have been disposed of on summary judgment. If there are any other questions, I'm happy to answer them.
I don't believe there are. Thank you very much, both of you, for your argument. Okay, well, wait a second.
I just wanted to know if I could have just a minute of personal privilege and I won't speak for the whole court, but I think I probably could. But this case is obviously very important to both parties in this case, and I just want to commend you lawyers for giving it the attention that it needs, and for the fine job you've done in presenting your briefs and in presenting your arguments today. I appreciate both of you for that. And that's it, Judge. I just wanted to put that out there.
Thank you, Judge. We appreciate it. All right, so that means that this case has now been submitted. I'm going to turn it over to Miss Williamson, and she will dismiss us.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now adjourned.